Yeah, here we are now with a very patient attorney at law and deputy public defender, Mr. Herbert McKenzie. We couldn't pay him for the information that he has been giving us free of cost, really, when you get right down to it, week after week, so that we can understand our constitutional rights. And he's armed with a lot of information this morning as we dissect the subject, the law of possession. I cited some examples earlier, and I'm going to allow Mr. McKenzie to go right into it. First of all, we say good morning, thanks for your patience, and welcome, Mr. Mack. How are you today?
I'm fine, thank you, sir. Good morning to you and your listeners.
All right.
This morning.
Yeah, man. Good to have you. The law of possession is what we're talking about. Am I right?
You are correct on that one. And it has some technicalities in it, which would cause us to wonder when people who are charged for illegal possession of firearm, illegal possession of cocaine, ganja, illegal possession of a lead sheet, and all those sort of cases, you see them walk out of court, and we wonder how that happened.
And it has happened very quite often, as a matter of fact.
In fact, recently, an AK-47 was found in a vehicle with some men in it, and they walked free. And, you know, it's really, the law of possession is a fairly technical piece of legal doctrine. But before I start, let me just explain right off the reel that possession and ownership are not one and the same. Possession is a technical term in law. And as I say, it usually comes to our knowledge, members of the consuming public, when people are charged with possession of firearm and ammunition, drug, lead sheet, pornographic material of children, that sort of thing. What it really is, though, you know, is it describes the situation where a person has a thing in his possession physically or under his control with the knowledge that what he has in his possession or under his control is actually the thing in question. So in other words, if I have a slice of cake, if I have a slice of cake in my pocket, for it to be possession of the slice of cake, not only would the cake have to be in my pocket deliberately, but I must know that that item is a slice of cake.
Oh.
Yeah. So now, based on that, it has certain elements about it. The definition alone. Knowledge of the thing in your possession and knowledge that you have it and that you intend to have it. The possession can be in two forms or two types. You can have actual possession, you can have what we call constructive possession. Constructive possession is that sort of possession which is attributed to the person by virtue of the circumstances in which he is. So, for example, let's use the one with the people in the car. If you go into this car and if you want to call it a taxi, and on the seat on which you are going to sit down, you see a 9mm pistol, and you decide to sit on it. It doesn't cause you any discomfort. Even though you don't actually possess it, the law vests in you constructive possession because you know it is there. You choose to shut your eye to be obvious to pretend that it isn't there. So you would be vested with constructive possession. Now, you know, if you're in studio, you're in a building, your car is parked outside, you're not in. The car is not exactly in your custody, you know, but it's still your car. The car is in your possession because you can't drive the car into the studio to sit around the desk or into your office to sit and share with you. But it's no less a car in your possession. Now, having said all those, let's look at a scenario now where a man or two men, three men found in a car in which an AK is, and they all walk free. First and foremost, the owner or the person in control at the time of the conveyance or in control of the building at the time
Yes.
is what the law says, prima facie, in control, in possession of the thing. And until the prosecution ups it or the person disproves it, then he's not in possession. Now the AK in the car. If that AK is in a bag concealed, fully concealed in a bag, none of the passengers who go in that car can be said to own the AK unless A, you can prove that he knows about it, he put it there, or you can prove that it's somehow his. example came out one time with a Pro Box. You know, the Pro Box, the back seat of the Pro Box opens into a large trunk space area. So if you look over the back seat, you can actually see in the front of the Pro Box, as it were.
Mm-hmm.
Car was stopped some time ago. And one of the passengers had a 9mm pistol. It's a real case I'm telling you about.
Yes.
When he saw the police at the checkpoint, he tossed the pistol in the back of the Pro Box. Now, anybody in the back seat turn up and look in the back of the Pro Box, so you see the pistol lying there on the floor. So when the vehicle came to a stop and the police searched, there it was in sight for all to see. It's big 9mm pistol. Everybody in the car disclaimed ownership. Everybody. No, strategically, the prosecution will have to charge everybody. And let me tell you why. Say you have A, B, and C in the car. If you charge A alone, they will say, not my gun, I don't know anything about it. But B and C are left, and you can't prove it is A. And you charge B, he will say the same thing. He will say the same thing, and not mine. So the prosecution will charge everybody. Let everybody come to court.
I can understand, like, the fact that the passengers would maybe put that argument forward, but then some of my listeners are thinking too that maybe it would come down then to the driver who, or maybe the owner who could possibly be the driver at the time. But
precisely, he's prima facie the person.
Yes.
But the driver can simply say, "I didn't see that he come on there. I saw him with a bag." And he put the bag in the back of the car. I didn't know. Or the driver can say it's a small firearm, like a 9mm pistol, which can be concealed in the pocket. I didn't know that he had it on him. I didn't know that he threw it in the back of the Pro Box. And in the case I'm citing to you, the driver was charged, and the driver was actually put on bail. And he came to us, and we have to explain to him, say, "Mr. Driver, if you had spoken up at the time that it's not you, you wouldn't end up being charged. Or you are the driver, you are primarily the owner of the car." And that case is still pending in court down by the western side of the island.
Yes.
It hasn't been resolved as yet. But that's how it is. Let's move it now to a M16 or an AK, a big shotgun.
right,
If it's not in bag, you can't really conceal that because you can't put that in a pocket. And if everybody is in a car full of passengers, and the AK is found lying on the back seat or between the driver and the passenger or on the floor of the passenger seat, and the police stops the car, and everybody comes out and deny knowledge, everybody will have to be charged, and in all likelihood, everybody will be convicted. Because that is what is called constructive possession. You would have closed your eyes to the obvious because you don't care to know that an illegal weapon is in the car in front of you. So you see, it comes back to definition. Knowledge that the thing is there, and knowledge that the thing is a thing. You don't think it's a fish rod. You know that's a M16. You can see it. So with that sort of knowledge, the court vests in you possession, whether actual or constructive, and you're liable in law. And the same thing happens for ganja, cocaine. Let me give you a quick case before the time runs out. This is a real case. Happened some time ago.
tell us.
In Montego. I think it's Montego Bay.
Mm-hmm.
This man was held with something like an IS, full of ganja from ground to floor. When the police held him, the vehicle was stopped, the police search. Stopped the vehicle because the stench assaulted their nostrils. Came to him. His defense was, "Boss, I don't know about this, I had the vehicle here. The owner for the vehicle came for it, he told me to wait here on him. Drove it, go somewhere, came back about half an hour time and said I must take the vehicle and go on with it." Now, that is good. So good that he was acquitted. But the authorities appealed the acquittal, and it went all the way to the Privy Council. And people said, no, the conviction, this is a conviction. What he did was to actually close his eyes to the obvious because he didn't want to know that it was ganja because it was right in the back of the vehicle behind him of the driver. The stench was there, the vehicle was loaded. He couldn't even see through the rearview mirror. Mm-hmm. They fixed him with constructive knowledge, and he got convicted. So, in the absence of things like those, people will always be walking away from court if they can't prove possession because of the technicalities.
So the matter of reasonable doubt, then, Mr. McKenzie.
Yes.
What role does that concept play in cases involving shared spaces like cars and so on, where multiple people could potentially claim or deny possession?
All right, let me address that. Reasonable doubt arise when the evidence is such that it leads the court, whether it's a judge or a jury, in a state where they are not quite sure. In other words, the prosecution hasn't convinced you beyond that reasonableness of doubt that the persons charged are the owners. And simply, the court look at the facts in front of it and the evidence. All the examples I've given to you, these are things that the court look at. Let's use the example with the man in the vehicle full of ganja.
Mm-hmm.
There can be no reasonable doubt that he was in the car because he was held there. There can be no reasonable doubt that the item was in the car was ganja. No matter what it says, I think it would have taken divine intervention to prove that he couldn't, by virtue of smell and sight, that thing wasn't ganja. So in his case, reasonable doubt doesn't arise. Let's give you an example in which reasonable doubt could have arisen, but it didn't. And in fact, it will tell us what the law of possession is when it comes to sleeping. There was a man in Johnsonville, Montego Bay, some time ago. This case was from the 1970s. So after sleeping in his house, police had information and barging on the house on him. Woke up the gentleman. So frightened and startled was he that he nearly jumped out of his skin. When they woke him up and searched him, they found a little pistol in his left-hand front pocket. Well, the charge him and his defense was that, I don't know who got in my pocket. I went to bed just like this, and I woke up and you wake me up and find a pistol in my pocket. The court said, no. As far as sleeping is concerned, once you have been awakened and the item is found upon you, it is yours, it is in your possession. And insofar as reasonability is concerned, none is there. You can raise it by establishing that it wasn't there when you went to sleep. So
yes.
The doctrine on that is, once you're asleep and the thing is found on you, when you wake, the court, as far as the law is concerned, the item is in your possession. You can't just go to sleep with the item and then wake up and say, oh, it wasn't there before. You have to establish that. So all reasonable doubt in that part case would have been removed once you have been awakened and the item is found upon your person. Be it lead sheet, be it gun, be it ganja, cocaine, whatever it is. I know we started late. I see the time is upon us, but you have another question.
I just wanted to ask you before you go, though, Mr. McKenzie, whether or not we're contemplating looking at revising this law of possession, because it seems like almost like there's a loophole that many people will, including some persons who would otherwise be found guilty, are walking scot-free.
Well, yes, it can be revised.
Yes.
But people will always walk scot-free because no law is so ironclad that people can't get around it.
Okay.
But right now, on the common law as it is, people can easily walk as free as easily as they can be convicted upon it.
Okay.
The real situation is, especially in these passenger types circumstances, when a gun is found in a vehicle, in which you're a passenger or a patron, you speak the truth. If you don't know about it, you don't know. If there's a big gun there, when you obviously see it, what you do, if you want to avoid being targeted by the owner who can come and knock you up, that's reality in Jamaica. When you tell the police no, when you have your quiet time, you go back to the police, I go to your lawyer, I go to your GP, I go to somebody and say, look, I knew it was there, it was a Tom Jones. I couldn't tell you that because they're going to kill me.
Oh.
But if you're maintained in the clear, obvious presence, when anybody would have known that you have this light pole of a gun in the vehicle beside you, oh, me never see it, is not mine. You're basically sinking your credibility and sinking yourself simultaneously.
Excellent advice. I really appreciate this. Thank you so very much, Mr. McKenzie. We covered a lot today on the law of possession. I thank you and I wish you a great day. Take care.